urgency. We're all practicing lawyers. And what we try to do is create an arbitration bar which over a period of time hopefully will create an arbitration culture that somewhat resembles what we see in different parts of the world. I think the government has made a start. The Law Commission has recommended big changes in the new arbitration amendment bill. But having said that, we inaugurated the Mumbai part of the Indian Arbitration Forum almost 1 year ago when Justice Ajit Shah simply had just published his report. Now we understand that on 26 August, the Cabinet has now approved this arbitration amendment, and hopefully when Parliament starts functioning like a Parliament again, it might actually get passed and we will start getting some results. I mean, two of the issues that have arisen in that which are eye-catching is, one of the recommendations is that all arbitration in India be concluded within 1 year and with a possible extension of 6 months, which is all very healthy, and we just want to see how that's going to work. Presently, as you know, most of the arbitrations are run by retired judges, some of whom are absolutely first-rate and work completely conscientiously, but the pace is still slow. And we're now hoping that, like international arbitration, the arbitrators start imposing time limits on how much the witness can be cross-examined, and parties are forced to stick to time limits. More and more written arguments, and reduce the oral arguments to an absolute minimum. We also hope, like other places, the arbitrators will actually read the papers in advance so that we don't have to have prolonged arguments and repetition and repeating and reading of Supreme Court judgments. That's been the bane, and that's why it's taken so long for some of these arbitrations to get completed. We're also trying to create a panel of non-judge arbitrators, people who are experienced, people who have integrity, people who are well-known in the field and have conducted a large number of arbitrations themselves, so to create a new climate. And we hope that, in a sense, will start progressing arbitrations considerably faster. And like I said, with time limits imposed, and we hope that having imposed time limits, the courts don't take an adverse view of that and say there wasn't sufficient hearing or some sort of breach of natural justice. We're hoping it doesn't come to that, because there's no way you're going to complete arbitrations in 1 year without that. We also know the other problem with the arbitration in India is the slow pace in courts. While the judges are more and more very pro-arbitration and giving fairly strong judgments in favor of upholding awards by and large, the problem is it just takes so long to get a hearing, and then you have 3 rounds. You have one in either the High Court or the District Court, 1 round in appeal, and then potentially the Supreme Court. Supreme Court is great because at least there's a barrier, so they have an admission time to the SLP, and we know how fast the SLPs are disposed of. We've all had our experiences with that, and but at least there's a barrier so that the matter not prolonged for a long time. And we're hoping to see that more and more lawyers are able to take arbitration the same way it's done on an international level, with the same intensity, with the same results. Because frankly, that is a proper dispute forum, because it's very difficult to get disputes decided in court, because the courts are overburdened. They take a long time, they work very consciously, but are completely and totally overburdened. And unless we make arbitration effective, we're not going to progress very far. And the judicial aspect is probably the one aspect where India is not moved at the pace of the other economic reforms. We've seen it time and time that you will have all of us who've had foreign clients say, look, we'll do anything, we're happy to do business in India, but we do not want to decide any disputes in India. How do we get out of it? So we're very proud to have with us Justice Nariman, who's probably given the most progressive judgment on arbitration in recent times, with the Associated Builders, which comprehensively deals with the issue and gets great guidance for all the courts as to when awards can be set aside and to what extent they need to be probed, etc. We've already had Justice Lodha's decision on Lal Mal on foreign awards, where he takes a view that since the award process is complete, the public policy issues will be very, very, very limited. And we're hoping to see those judgments followed more and more in the high courts, the district courts, because even today, don't forget that the district courts are hearing the bulk of the challenges to awards as well as the foreign awards. We've all had our own experiences there, so we don't want to comment on it further, but we're just hoping with this new regime, both with the Civil Courts Bill and the new arbitration amendment, we'll see progress in terms of speed. Therefore, ladies and gentlemen, we request you to support the Indian Arbitration Forum, become members, follow us on the website. All we're trying to do is instill efficient practices so that the arbitration process is not prolonged and dragged out forever. We also hopefully that as sooner or later we will present an alternative list of arbitrators where parties, clients, courts can consider appointment instead of the same retired judges who are completely overburdened and will simply not be able to finish the arbitrations in the manner laid down by the court. With this, I want to take 2 minutes to just tell you a little bit about Gary Bourne, who's the chairman of the SEAC court. I was a member of the SEAC court with him for several years, and I've known him very well over the past years. Gary, apart from being the head of his law firm for the disputes practice, is an extremely able counsel, even busier arbitrator, and now as chairman of the SEAC court, and also as a prolific writer. One day when I was at dinner, I asked him, I said, Gary, you wear these so many hats. Where do you get time to write these books? He said, you won't believe it. I only sleep 3 hours a day. I spend all night writing. So he's got a commendable career, and now as chairman of the SEAC, he's all over India promoting SEAC and doing a terrific job of it. Of course, Justice Nariman needs no introduction. We all know him at the bar and at the bench, and like I said, we're very proud of his recent judgments on arbitration, which have been real eye-openers for most of us. Won't take more time now. We'll now request Gary Bourne to address the audience. Thank you.
Thank you so much, Hiru, for that very kind introduction. Thanks also to the India Arbitration Forum for having me here this evening, and perhaps most importantly of all, thank each of you for coming here to listen to me. Some of you I have to thank particularly because I think you listened to me earlier today, and I'm sure, at least to some extent, you're tired of that, and I apologize for your having to hear me yet again. I think, though, I'm going to change the focus to some extent of my presentation and the nature of my comments. This afternoon, throughout the course of today at the SEAC annual conference, we had a distinctly practical focus on arbitration. We looked at how, under the SEAC arbitration rules, and you'll forgive me a small commercial break here, we conduct arbitrations efficiently, cost-effectively, practically, pragmatically. My comments today, for those of you who have already heard me this afternoon, are not pragmatic, they're not cost-efficient, they're not expeditious. Instead, I'm going to focus on theory, because this is a forum. And what I thought I would talk about is the right to arbitrate. And because that's a little esoteric, I will need to develop this right to arbitrate over the course of my remarks in the next, I think, 20 minutes or so that I've been allotted. Now, we all know, Hiru mentioned, that arbitration, international arbitration in particular, has become a preferred means of dispute resolution. We can see evidence of that all around the world. We can look at the institutional caseloads at SEAC, for example. Our caseload has been going steadily up year on year. We can look at the caseloads of our competitors, the International Chamber of Commerce, the LCIA, what have you. All of their caseloads increase. Arbitral institutions, which 2 decades ago barely existed, ICSID, the International Center for Settlement of Investment Disputes, and had a caseload of under 1 a year on average, 1 arbitration a year, now are recording in the hefty double digits. And it's not just in the number of cases, but it's the size and quality of cases. One sees that the size of disputes increases from being small matters to being very large matters. The Yukos arbitration award against the Russian Federation, $50 billion just earlier this year, is a little bit out of the ordinary, but it gives us some sense of not just the number of cases, but the magnitude of the disputes that are being submitted to arbitration. At the same time, one sees not just ordinary commercial disputes, which was the historic bailiwick, if you will, of international arbitration, but instead a whole range of new types of disputes: sports arbitrations, investment arbitrations, commodities, insurance, a whole range of different sorts of disputes, including even now class action arbitrations and the like, which historically were matters for exclusively national courts. The commitment of commercial parties to resolving their disputes by international arbitration, by arbitration of any sort, is in part because of the benefits that the arbitral process promises and hopefully in most cases brings, namely an efficient, neutral, cost-effective, commercially sensitive, and above all else, perhaps in the international context, enforceable means of dispute resolution. Because of the New York Convention, the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, with 156 contracting states party to that convention, both international arbitration agreements and international arbitral awards enjoy a sort of global currency. They are enforceable in all 156 contracting states around the world by virtue of the global constitutional charter for international arbitration, the New York Convention. And equally, arbitral awards, once they have been obtained, can be enforced. They're portable. They can be enforced around the world in all 156 contracting states. And it is because of that enforceability, that commitment of states around the world to the arbitral process, that arbitration, international arbitration in particular, has enjoyed such substantial popularity over recent decades, over recent years. That said, we can't lie on our laurels, and one must remain vigilant. One must remain vigilant in part because history always is cyclical. History is always cyclical, including with respect to judicial attitudes, to some extent even legislative attitudes towards international arbitration, towards arbitration. There has been a history of judicial hostility in many countries, and I'll speak a little bit about this in a moment, towards arbitration, often focused on the notion that arbitration is a sort of second-class justice. It's a kind of rough justice that doesn't really accord with the rule of law. It deprives, in particular, citizens of their rights, their individual rights of access to the courts, and it deprives the legal system of the legitimacy and the correctness of judgments decided by national courts. And that sort of hesitance, that sort of skepticism about the arbitral process is something that has been recurrent throughout history and that has led to criticisms, and what I'm going to read from now goes back a century and a half ago to the 1840s in the United States, to one of the great American jurists, Joseph Story. What he had to say is something that is reflective not just of the 1800s, but even of 2012, 2014, 2015. It is a sentiment, an attitude towards arbitration which is recurrent and which demands, as I said previously, vigilance on the part of all of us in the arbitration forum, in the arbitration community, because these sorts of critiques can't go unanswered. They must be responded to. They must be taken seriously. This critique was as follows. Joseph Story said as follows. Now, we all know that arbitration at the common law, arbitrators at the common law, possess no authority whatsoever, even to administer an oath or to compel the attendance of witnesses. They cannot compel the production of documents and papers and books of account, or insist upon a discovery of facts from the parties under oath. They are not ordinarily well enough acquainted with the principles of law or equity to administer either effectually in complicated cases, and hence it has often been said that the judgment of arbitrators is but rusticum judicium, rough justice. And the consequence that he drew from that was that agreements to arbitrate were not enforceable. They were valid, but they were not specifically enforceable, rendering them effectively useless in the United States for some 80 years. This position was not an outlier. This was not unusual. The English courts adopted similar views, only being rescued by statutory instruments. In France, a classic decision, also ironically, in the 1840s. The Americans and the French don't usually do anything similarly. In this case, the French Cour de Cassation took precisely the same view in a decision called Prunier versus Alliance, in which the Cour de Cassation declared agreements to arbitrate future disputes invalid and unenforceable on the basis that persons that were appointed as arbitrators might not, quote, be able to deal with the matter and worth the confidence the parties would entrust to them. Again, the basic notion that arbitration provides rough justice, not real justice, and thereby compromises both the rule of law and individual rights of citizens. This is a serious critique, one that the arbitral community must answer. And the answer to it, I would suggest, and that's the principal focus of my comments this evening, the answer to it is that has it exactly backwards. It's exactly wrong. The right to arbitrate is a fundamental right of citizens and is as important to the rule of law as other rights of citizens. Just as citizens have the right to marry whom they choose, the right to contract as they wish, the right to associate as they will, so citizens have the right to settle their disputes with their contracting parties, with their spouses, with those in their associations as they will. At the end of the day, disputes, the way to fix disputes, to mend relationships, is a fundamental aspect of individual rights, individual autonomy, and preservation of those rights is fundamental to the rule of law. And that is something that I think appeals not just to our common sense of justice, but it's something also that one sees, just as one finds recurrent judicial hostility to arbitration through the ages, one also finds recognition of this thing, this right to arbitrate, as I have called it. And what I'd like to do in the time remaining is to refer to some examples historically in diverse cultures of this right to arbitrate, which is, I would suggest, so important to the fabric of our legal culture today, both here in India and elsewhere. I'd like to begin with going back to France, where, as I mentioned previously, the Cour de Cassation held arbitration agreements invalid on the basis that they compromised the rights of citizens. That, in fact, in the 1840s, was a dramatic about-face from the 1792 Constitution of Year One, the French Revolutionary Republic. That Constitution of Year One, in fact, contained within it a constitutional right to arbitrate. In the Constitution, the French regime guaranteed to citizens the right to resolve disputes by persons of their choice, a constitutional recognition of the importance of the right of individuals, the right of businesses to resolve disputes as they would. Subsequently, after the Prunier decision that I have referred to, France again came back to the fold, came back and saw the light, if I can put it that way, and in the Geneva Protocol in the 1920s, adopted pro-arbitration rules of interpretation, pro-arbitration rules of validity, and more recently, France has been in the forefront of pro-arbitration legislation giving effect to international arbitration agreements. In Germany, a similar dynamic occurred. In 1877, the Prussian Code of Civil Procedure adopted a very pro-arbitration approach to both international arbitration agreements, domestic arbitration agreements, and awards. It was a legislative regime that looked very much like the UNCITRAL model law that we're familiar with today. Come the 1930s, with the Nazi regime, there was, in place of the 1877 Commercial Procedure Code, something called the Reich's Guidelines regarding arbitral tribunals, which declared, and I'll quote from these, "From a state political point of view, a further spread of arbitrations would shatter confidence in state jurisdiction and the state itself." The basic philosophy of the Nazi regime at the time was that individual autonomy, individual businesses, individual people deciding how they wanted to resolve their disputes between themselves was a threat to the totalitarian regime and therefore should be forbidden. The good news is that by the 1960s, the German liberal court regime that had replaced the Nazis after the Second World War adopted exactly the opposite point of view. And in a very well-known German decision, making use of guarantees of individual rights in the German Constitution, the German Basic Law, the German Supreme Court announced the following: "The right to agree upon submitting a matter to arbitration is contained in the fundamental right of freedom of contract under Article 2. The restriction of state jurisdiction occurring as a result of the agreement to arbitrate is a result of the parties' exercise of freedom of contract." A basic recognition of the importance of the right to arbitrate, to any constitutional regime, to individual rights, to the rule of law itself. And although I reminded you of Joseph Story's views, negative views about arbitration and rough justice in the 1840s, come the 20th century, the U.S. courts adopted a very different viewpoint. They said, and I'll quote from a Hawaiian Supreme Court decision, "The recognized autonomy of parties to enter into an arbitration agreement is directly correlated to and stems from the constitutionally protected right of freedom of contract." And the United States, in the Federal Arbitration Act, adopted exactly the same attitude, giving effect to agreements to arbitrate. There have also been international tribunals, the ATA versus Jordan Investment Arbitration Award and the Saipan versus Bangladesh Arbitration Award. In each case, investment arbitral tribunals concluding that national court decisions denying effect to arbitration agreements constituted denials of justice in violation of bilateral investment treaty guarantees and of customary international law itself. This corpus of decisions from widely diverse national jurisdictions, from international tribunals, in my view, reflects an emerging right to arbitrate, reflective of the importance of individual autonomy in the resolution of disputes ultimately between individuals who every constitutional regime that you look at guarantees those individuals the primary voice in how their disputes ought to be resolved. At the end of the day, the response to those who would criticize arbitration as providing second-class justice and undermining individual rights and the rule of law is that those critiques have things precisely backwards. In fact, it is arbitration, a recognition of the individual autonomy of citizens to resolve their disputes as they think best, to mend their relationships in the manner they think wisest. Recognition of that autonomy does not undermine the rule of law, it advances the rule of law. It does not undermine the rights of citizens, it advances the rights of citizens. And we in the arbitration community ought have no hesitation to stand up and say precisely that to the critics of what it is that we do. Thank you.
All of us in the arbitration field done something. At least I had no idea that arbitration awards are not recognized at all and was treated as rough justice. But that's why we're all here, to learn something new. Our next keynote speaker is Justice Nariman, who of course needs no introduction, and we've all known him both at the bar and the bench as an outstanding lawyer. And my only claim to fame is we actually went to the same high school. So with that, I'll say Justice Nariman. Mr. Gary Bond, Mrs. Pallavi Shroff, fellow cathedralite, hero,
my beloved parents, ladies and gentlemen. Thank you, Mr. Bond, for your extremely illuminating analysis of the right to arbitrate. I was wondering what I'd speak about this evening, so you've given me so much fodder that, I don't know where to begin. But let's begin at the beginning. You took us back to the year 1792. I propose taking you back to the year 1689. And I'll tell you why in a minute. But one other very interesting thing about Justice Joseph's story. He was a genius. He was made a US Supreme Court judge when he was only 32. And it's a sobering thought that by 32, Alexander, Shankaracharya and Franz Schubert were dead. But this man, according to the greatest Chief Justice perhaps in any jurisdiction, John Marshall, was considered so learned that he'd say Brother Story knew everything from the 12 tables downwards. And I'm surprised that Brother Story ultimately came to the conclusion that he came to. But I must tell you that in this country, we were a little more progressive. In 1872, which is the year of our Contract Act, which is about 30 years after Brother Story's judgment, we in our section 28 already had an exception, because agreements in restraint of legal proceedings are void. Exception 1, the right to arbitrate. So we were progressive. And we were progressive because basically we took on the mantle of English law. Now in England, obviously something very different had happened. The right to arbitrate was considered as something private and outside the courts of the King's Bench. This continued till the year 1688. Now why is 1688 significant? In English history, it's extremely significant for two reasons. One, the first Dutch ruler of England ever came and was called to rule, William III. Now he happened to be called because he was Protestant, no other reason. And James II was a Catholic king who had just been expelled in the Glorious Revolution, so-called, because there wasn't a single shot fired. The king had to go down the tower and quietly go down a boat, in a boat by himself down the Thames, where he dropped the Great Seal of the Lord Chancellor into the river and pushed off to his cousin Louis XIV in France. Now, William, therefore, came at a period when Parliament thought that it had great bargaining strength, because he ruled jointly with his cousin, Mary, who happened to be James II's Protestant daughter. So Parliament decided that they would have the first real Bill of Rights of 1689. Various expressions well known to us, such as the 8th Amendment expression, cruel and unusual punishment, all come from this Bill of Rights. And interestingly enough, another burning topic of the day, over here at least, is appointment of judges. And that Bill of Rights sought for the first time to make an inroad into the doctrine of the king's pleasure so far as appointment of judges is concerned. Because till then, the moment a monarch left, the next monarch could either wholesale do away with all the judges, continue then, put whoever he wanted, and so on and so forth. But Parliament for the first time asked the king to sign a Bill of Rights which guaranteed both tenure and salary. The king refused to do so for another reason. He refused to do so only because he said, you are making me sign something which is already part of your law. This is not part of your law. So I refused to sign it. And they had to wait till the reign of his sister-in-law, Queen Anne, when the Act of Settlement was passed in 1701, to ultimately secure the tenure and the salary of judges. But all this is by the way. Why we go back to King William III is because for the first time, Parliament by a statute stated that a private tribunal would now be controlled by the courts of the King's Bench. And the only ground for setting aside a private tribunal's award, as it was called in those days, was the ground of bribery or fraud. There was no other ground. We now move on till the year 1802, which is a long shot from 1688, 100 years plus. And we then come to another decision of the Court of King's Bench, Kent versus Elstow. And in Kent's case, for the first time, what we know in India as the Chamse Bara principle was applied, namely that if an award happened to be or happened to have on its face an error of law apparent, then on that ground also it would be set aside. Now, this principle was borrowed from administrative law, interestingly enough. And as we are told by Lord Denning in the Northumberland case in 1952, administrative law itself did not use this principle for over 100 years. So it was a borrowed principle. It came into the law of arbitration. Administrative law went back to the classic jurisdictional aspect of the writ of certiorari, and errors of law apparent were not revived until 1952 in England. We in India were governed by this principle even before the Privy Council's decision in Jivaraj Ballu versus Chamse Bara, which is why it's called the Chamse Bara principle, a decision of the year 1923. And this principle is so ingrained in our minds that it continued in our 1940 Act, even though it wasn't expressly stated there, and continued to be applied by all the courts. The stage is now set for the new 1996 Act. But just before that, we had, as you said, the New York Convention of 1958. We were one of the early signatories, and we had a Foreign Awards Recognition Act of 1961. Now, we bodily lifted the grounds in Article 5 of the Convention and made it part of Section 7 of that 1961 statute. And the basic thing that confronted our courts when foreign awards had to pass muster in India for recognition and enforcement was the public policy exception. Now, in India, lawyers are familiar with the phrase public policy as an aspect only of contract law. This occurs in Section 23 of our Contract Act. And by the time the Foreign Awards Act came in, we had a decision of the Supreme Court, Kherulal Parakh in 1959, which stated that at least in contract law, the heads of public policy were closed. You had some 10 recognized heads. It was described otherwise as an unruly horse, etc. And the judges in India were told in 1959 that at least so far as the law of contract is concerned, this head can no longer be expanded. It contained within it those 10 particular topics, such as trading with the enemy, champerty maintenance, etc. And this continued right till the 1980s, when we had a very illuminating judgment of one of our greatest judges, Justice Madan. He was a Parsi priest like me. And he wrote one of the most brilliant judgments in the Central Inland Waterways case, a very well-known judgment, where he referred copiously to and extensively to English law and arrived at the exactly opposite conclusion that given our constitutional fundamental rights, guarantees, etc., the heads of public policy are never closed and must be opened when justice so demands. Now, this is how contract law stood at the time that public policy now crept into private international law through the Foreign Awards Act. And the first time we had ever to confront this problem in the private international law scenario was in the Renusagar judgment, which is the judgment of our court, it delivered in 1994, 2 years before this act came into force. And there again, Justice Agarwal, who wrote the judgment, being a good civil lawyer, began with the Contract Act position, because we were obsessed by that somehow. And then said that because there are two views, the Gherulal Parak view, 59 view, and the 1986 view, you can construe this either narrowly or broadly. And in the context of private international law, given the New York Convention, given the fact that judicial interference should be minimal, etc., we will adopt what we call the narrow view. Now, the narrow view, again taken from a number of English judgments, comprised three basic things. The first was described as the fundamental policy of Indian law, as vague as you can get. The second was described as against the interests of India. And the third, this being a narrow view, was the award being contrary to justice or morality. Now, justice takes in pretty much everything, and morality again takes in pretty much everything. It's almost as if you are in a complete equities jurisdiction, not bound by law, and the Chancellor's foot in every case can decide that this award is contrary to justice, that award is contrary to morality. But anyway, this is what Renu Sagar laid down in 1994. The present act comes into force in 1996, does away with the Domestic Act of 1940, the Foreign Awards Act of 1961, the Geneva Convention Act of 1937, and brings arbitration within one particular act and divides it into parts. Part 1 deals with the domestic scenario, Part 2 deals with the New York Convention scenario, Part 3 Geneva Convention, Part 4 miscellaneous, etc. Now, interestingly enough, the draftsman of this particular statute again bodily lifted Article 5 of the New York Convention and made it Section 48, which occurs in Part 2, which deals with recognition and enforcement of foreign awards. Strangely enough, he also lifted this and put it into Section 34 in Part 1, barring one particular ground, which would apply only to foreign awards, namely that they have to be both binding in the country in which they were delivered and they should not have been set aside in that country. So barring that one ground, the entire Article 5 of the New York Convention was picked up and put into our Part 1, which deals with challenges to domestic arbitrations. Nobody had quite thought that international arbitrations which took place in India would also be governed by Section 34. That I don't think was present at the forefront at that time. So that could not possibly have been a reason for picking up the New York Convention and suddenly making it exactly the same so far as domestic awards are concerned. But anyway, that was done. And we therefore started off with, let us put it this way, a Renu Sagar regime so far as Section 48 was concerned, that is the foreign award part, whereas I told you we had these two at least extremely vague expressions, fundamental policy of Indian law and justice and morality. And all hell could have broken loose depending on which judge felt which way. Now, Renu Sagar itself made a distinction between errors of law, which were apparent, that is the Chamse Bara principle, and the fundamental policy of Indian law. And it did it this way, it did it textually. It went by the old 1937 Geneva Convention Enforcement Act here, which had a similar provision to Article 5. The difference being that public policy of India was followed by all laws of India. So the court reasoned obviously, if it is contrary to the law of India, it couldn't also be contrary to the public policy of India. They're two separate things. Being separate, therefore, public policy of India, now construed as fundamental policy of Indian law, could not, therefore, have error of law apparent on the face of the record in it. So far, so good. So that was one restrictive aspect. The other was, a differentiation was made, not as clearly as I would have liked, between public interest and other interests. Now you could have, for example, governmental interest as opposed to public interest. You could also have governmental interest as part of public interest. You could have individual interest as part of public interest or purely individual interest. But the court didn't make these fine distinctions. It just went on to say that on the facts in that case, the Foreign Exchange Management Act dealt with the economy of the country. It therefore dealt with public interest. It was therefore part of the fundamental policy of Indian law. It also said enforcement of court orders is another important aspect of Indian law, therefore part of its fundamental policy. So far, so good. Then comes a challenge in the context of the domestic scenario. Because don't forget, the same language is used in section 34 as was used in section 48, borrowed from Article 5 of the New York Convention. So, for the first time, the Bombay High Court dealt with such a challenge. I must tell you, unfortunately, Justice Sri Krishna's judgment in the Bombay High Court was never brought to the notice of the Supreme Court in the Saw Pipes decision, which is so well known. And that judgment specifically stated that whatever was public policy of India, the words of India were added for the first time by this act, would mean exactly the same thing for a foreign award as it meant for a domestic award. And therefore, the so-called narrow interpretation was preferred. A year after that judgment, which was delivered in 2001, in 2002, we have this famous Saw Pipes decision. The Saw Pipes decision reasoned as follows. It did not open either the hydra head of interest of India or justice or morality. What it did was to add a fourth head. And the fourth head now became patent illegality. Now within this broad rubric fell three other things. First, 28(1) of the 1996 Act, in a completely different context, said that in a purely domestic arbitration between, let's say, two Indians, the two Indians obviously cannot contract out of the substantive law of India. They have to apply the law of India. But the court read that provision as meaning that since all awards made under this part are subject to the substantive law and have to conform to that substantive law, comes back the principle of error of law without any of the things like error apparent, for example, or on the face of the award or some document appended to it. So, any law now infringed would immediately cast the death knell of an award. So this opened the door very, very wide. Secondly, it said, contrary again to a large number of judgments which said that the arbitrator ultimately may be bound by the terms of the contract, but ultimately it is his interpretation of the contract which should be preferred, unless it's something so absurd that the court has to interfere. It read section 28(3) of the Act to say now that since the arbitrator is bound by the terms of the contract, if the court says that the contract is X and the arbitrator says it is Y, again, out goes the award. So it opened really a huge floodgate. And in this country, awards started getting set aside much, much more than they should have. What was forgotten was Lord Mansfield's exhortation to a general who was given plenipotentiary powers, including judicial powers, when he went to Jamaica to rule it. He asked Lord Mansfield for his advice and said, "What do I do when I have to judge cases?" He said, "Do as your head and your heart dictate. By and large, you'll be right, but see that you don't give reasons. Because the moment you give reasons, somebody will interfere with them and your award will be set at naught." Now, interestingly enough, the sawpipes regime, so to speak, continued for a decade here. And not only did it continue, its effect was felt in the foreign award area as well. Because in 2011, our court, in the Fulchand exports case, decided that what is good for a domestic award should also be good for a foreign award. And therefore, out goes the narrow view, in comes in the massive broad view. So that even foreign awards, when they had to be recognized and enforced here, had to conform to the drill of sawpipes. This fortunately was done away with in a recent judgment in Sri Lal Main, so that at least so far as the foreign awards are concerned, you go back to the old Renu Sagar position. But so far as the domestic position is concerned, one more Hydra head raised itself in a very recent judgment in Western Gecko. We thought that the fundamental policy of Indian law was now construed by Renu Sagar to mean X and nothing more. A very recent judgment of my court laid down that it meant three other things now. And the three other things were, one, an award could not be arbitrary. It had to conform to basic judicial standards. It couldn't be contrary to natural justice, point 2. And point 3, the administrative principle, once more, borrowing from administrative law, of the famous Wednesbury case, Lord Green's famous paragraph, that if you take something irrelevant into account, it is bad. If you do not take something relevant into account, equally your order is bad. And if no reasonable person could have passed the order, again it's bad. All this became part of fundamental policy of Indian law. Now with this massive broadening again, and don't forget, this would apply to the international scenario as well. The Law Commission has now delivered a report, and it is yet to be seen as to whether Parliament will accept it in its entirety, not accept it in its entirety. But we know one thing, that ultimately what they have done is to say that fundamental policy of Indian law cannot possibly go to merits. So that all these three tests go. And you restore the old Renu Sagar position. They have also recommended that any award that is contrary to the interest of India equally will go. The interest of India exception has been removed. And they have said that justice and morality now can no longer be something open-ended for yet another decision to say that something is unjust. But it must be the most basic notions of justice and morality, something that shocks your conscience. It must be something egregious for you to then say that an award should not be recognized and enforced. It is yet to be seen whether this is accepted or not accepted. And interestingly enough, it has reinstated the Chamse Bara principle. And this principle, it is reinstated only for the domestic arbitrations, not for international arbitrations, whether conducted abroad or in this country. We have yet to see whether this commission report, we hope that it will, Parliament in its next session, will at least apply its mind to it. And if it does so and passes it, there will be a great deal of stability brought back to this area of this troubled area of the law. One other interesting feature of our law has been the other problem which has plagued our jurists. Namely, what do we say about seat? We didn't give much of a thought about seat at all, because a seat has been likened to an exclusive jurisdiction clause. And early on we had a judgment in National Thermal Power Corporation versus Singer in 1992, before this act came in, under the old Foreign Awards Act. Now that act had a section 9B which said that arbitration agreements which were governed by Indian law were outside the scope of the Foreign Awards Act. The agreement that the court had to construe specifically had one particular clause for domestic arbitration and another for international arbitration. The domestic arbitration clause specified that the Indian Act 1940 will apply. The foreign arbitration clause said the ICC rules will apply. Given that, this court still said that since the substantive law of the contract is Indian, the law of the arbitration agreement will also be Indian, and therefore an award delivered abroad with the seat somewhere else would be a domestic award governed by the 1940 Act and not by the Foreign Award. This was done away with, fortunately for us, in the 1996 Act by enacting Section 51 in Part 2 and dropping Section 9B, so that one couldn't say that again. But despite that having been done, another problem arose in 2003. We had a situation where an award was to be delivered abroad, not yet delivered. The seat obviously was abroad. The ICC rules applied and the venue was Paris. The foreign party wanted to get interim orders against the Indian party in India, because if it succeeded ultimately, the Indian party might well do away with its assets or some such thing. So they wanted something in the nature of an attachment before judgment. And they were faced with this, that look, Part 1 applies only to domestic arbitrations. Section 9, which deals with interim orders, also applies only to domestic arbitration, and therefore out you go. In fact, that was the view of 5 high courts. But the Supreme Court stepped in and reversed. And reversed fundamentally on many grounds, but fundamentally on the ground that since this act really copied the UNCITRAL model law, it made a very significant omission in one section, in Section 2. And it said this part will apply where arbitration takes place in India, dropping the word only, when the place is India. So the court said the word only has been dropped. Since the word only has been dropped, we come back to this concurrent jurisdiction of the Singer era, and unless an agreement is so drafted that it expressly or otherwise by necessary implication does away with the Indian Act, even Part 1 will apply. And the logic of this decision was then applied in Venture Global's case in 2008 to say that a foreign award could be a domestic award at the same time. That actual reductio ad absurdum. Because a foreign award is separately defined in Section 44. A domestic award obviously is an award made in India. And they said, following this logic, that unless the agreement does not expressly or by necessary implication do away with the Indian Act, that foreign award can be tested 3 times over. Once in the country in which it is made, once under our Section 34, and then to recognize and enforce it by the other side under Section 48. Now all this, fortunately for us, was done away with by a 5-judge bench decision in 2012. But with a caveat. The caveat is this, that in the last paragraph, the bench then went on to say we are declaring this as the law only prospectively. All arbitration agreements that were entered into prior to our judgment will be governed by the old law. Now this again, the Law Commission has sought to do away with by saying that not only should the agreement be before the judgment, but there should be some pending application. And unless there's a pending application, the law declared by the Constitution bench of 5 judges will operate. Another very interesting feature is that ultimately recent judgments of our court have made this differentiation between seat and venue and done it quite well. They referred to a number of English judgments, the famous Shashwa judgment, the Braze and Douane judgment, Naviera, CND, etc. And ultimately said that foreign arbitrations must now be regarded as seat-centric. And the Law Commission again has defined seat to mean the juridical seat, where in fact the arbitration is supposed to be enforced, as opposed to a venue, and taken steps to see that if the juridical seat happens to be in India, only then will Part 1 apply and not otherwise. That again is a salutary feature of the law, and we hope that Parliament passes at least these two important aspects of the Law Commission report, namely the public policy exception as well as the seat part. There are a number of other little things they have done, including, as my friend Hiru said, tried to introduce time limits, tried to exhort arbitrators to go on day to day, tried to limit their fees, etc., etc. If all that passes muster, well and good. But ultimately, at the end of the day, the middle path is the real path that all of us should tread. And that middle path is that the rougher the justice that an arbitrator ultimately delivers by way of his award, the more will a court want to interfere. And that must never be forgotten. So institutional arbitration, which sees that the award is not only checked for flaws which are technical in nature but flaws on merits as well, would go a far way into ensuring that courts interfere as little as possible. Thank you very much.
Thank you session without referring to you. Rajiv, thank you so much for being here. Several other friends and colleagues from Delhi and across the world, thank you so much for being here today at this inauguration of the Delhi chapter of the IAF. I think we've heard two fabulous speakers through the evening. I think all our attention has been absolutely riveted to what both of them have said. I think the whole history of the right to arbitrate was indeed absolutely fascinating, Gary. And while one had heard bits and parts of all of this, actually the way you've put it across, I think was very, very fascinating. And I think it gave us a good relief, if I may say so, that Indian law was a bit more progressive than a lot of the other jurisdictions of the world, starting way back in 1872. And Justice Nariman has, of course, taken us through the various problems that we've all grappled with over the years in the field of arbitration. I think a couple of points that he made, I think, are so significant that one cannot but mention them as we do. I think the first would be the whole concept of the seat of the arbitration that he has mentioned. Even though there is, I think, reasonable clarity in the case law that has evolved as to the distinction between seat and venue, we still find our courts interfering, even which is in the middle of an arbitration process by way of Section 9, in spite of the fact that it's been held that Section 9 cannot lie. you have observations, you have findings, giving findings as to what should be the seat of the arbitration, not leaving it to the tribunal itself to decide seat of the arbitration. Interim orders, of course, has been an issue, and with BALCO, we still need to think, who are we advising as lawyers? Are we advising Indian clients? Are we advising foreign clients as to where should be the seat of the arbitration, right from the time when the contracts are being negotiated? I think a very important point that Justice Nariman just mentioned was that of institutional arbitration. I think that's a very, very fundamental point. We've seen over the years just ad hoc arbitrations in India, and that has essentially been the parties feel they have more control of the arbitrations, not realizing that at the end, those awards get set aside far more than if it were an institutional arbitration. But the challenge that parties have faced, and we as lawyers have faced, is equally the fact that the very few efficiently run and well-managed institutions that can conduct arbitrations in India. I mean, I can't think of one good arbitration center that I would want to refer something to, except till a few years ago we started the LCIA India chapter. So I think we need certainly a lot more domestic institutions which can actually do that. So I think any approach or any policy of the government or maybe private parties who can get together and set up institutions that can run arbitration is going to be absolutely critical. I think there is a move recently to have a sort of a privately funded and a privately done institution in Maharashtra. And I'm just hoping that with the help of people who are really interested in setting it up, something like that would actually take off and set an example, for many other institutions to actually buckle up and run them more efficiently. And think they could take an example from SIAC. I was among the first directors of SIAC when the board was internationalized, and we saw the progress that SIAC has made over the years. I think we have a lot to learn from best practices. And I think as part of the IAF, which is an arbitration forum of the arbitration bar, I think for any arbitration to be successful, I think there are various stakeholders in this whole process of arbitration, and we as practitioners certainly have a lot to contribute. And I think as members of the Indian Arbitration Bar, we can certainly get together and contribute a whole lot of things. For once, looking at our best practices, at least in the arbitrations that we are all involved in, we can insist on best practices, declarations of independence of arbitrators, which is something so basic and so fundamental, but is not practiced in India. I think starting with something as such, what sort of evidence are we going to lead? I have sat through arbitrations, and I'm sure all of you have sat through arbitrations where the traditional forms of evidence are being conducted, where you put a question or put a statement to the witness and the witness denies the statement. And so the whole case is I put it to you and then the witness denies it. And it just goes endlessly on and on. Those entire techniques of arbitration are outdated. We certainly need to do away with that. The arbitrators themselves need to control the process of arbitration more than we all want them to. Really, they need to do it if we have to promote the whole concept of quick, speedy, and efficiently run arbitrations. Finally, even the awards need to come fast enough. This is a problem not only with domestic awards. We've seen this even in international awards, where they take 6 months, 12 months, 9 months for awards to come, because tribunals or arbitrators are quite busy these days. So I think one more big thing that one challenge that we all face is the lack of infrastructural facilities. And if you look at SIAC or you look anywhere else, you have the ICDR in Fleet Street in London, or you have the whole ICC set up in Paris, or you will have the Maxwell Chambers in Singapore. India lacks one such center where you can go and conduct an arbitration, or you have the facilities where arbitration can be conducted. Arbitrations are conducted in clubs, or they're conducted in 5-star hotels. I don't think that's ideal for the long run. They're not going to be cost efficient at the end of the day because the amount that is spent on just the infrastructure to set up. The process is tediously slow because particularly when evidence is being led, because there is no verbatim transcript of what is happening. Some of them have a screen in the front, somebody's typing manually what's happening, and that's the way we progress. So what can take place in one day takes 7 days just because the entire process is manual. So we certainly need a huge amount of infrastructure for the conduct of arbitrations. We need to take arbitration seriously. We also need to stop doing these as part-time. And to that extent, from 4 to 7 in the evening after court hours, I think that is what we as members of the IAF or as the arbitration bar can contribute, certainly. And I think these are some of the challenges that we face, but there is a lot that we ourselves can do to promote the cause of arbitration in India. I think the other challenges that the courts face and they have dealt with over the years, I think have already been dealt with quite adequately, and I do not want to go through all of those challenges again. But I think if different stakeholders got together and put their mind to what can be done, I'm very confident that we can do what we really need to do, to put India on the map for arbitrations. So finally, I would like to end by thanking Justice Shakhtar, Justice Khanna, Mr. P.K. Malhotra, our sponsors, Accuracy and Cox and Kings. And really thank you all for being here this evening. You've had a long day at the SIAC arbitration and even now, but thank you ever so much for being here this evening. And can I request Ajay to come and felicitate Mr. Gary Vaughan?
Can we also give a gift to Justice Nariman, please? Yeah, Rajiv.
Doesn't look like me too much.
Ladies and gentlemen, with that, we come to the end of our speeches, and since it's Saturday night, you're all invited for cocktails now. Thank you.